Manhattan, were you terminated on your day off? The question of termination due to taking a day off is relatively complicated and will depend on the circumstances. Can my job make me work on my day off and fire me if I refuse? Firing an employee during his or her day off is an important question in employment law. Unfortunately, for most workers, the answer is yes. You can be fired on your day off for refusing to show up at work if your employer asks you to come. The employer is not required to change your work schedule merely because you request them to do so. But there are several instances where being terminated during a day off may be illegal, and I will describe them here. What is at-will employment? First, a bit of background on the employment law framework in almost all of the states would be useful to help better explain the current state of whether termination is illegal. Almost every state follows the rule of at-will employment, including New York. This means that employees can generally be fired at any time, for any reason, no reason, or even a false reason. This rule may seem draconian and ripe for employer abuse at first. However, the rule also benefits employees who can choose to take any available employment and quit at any time. An at-will employee can be fired at any time for any legal reason. If the employer decides to let you go, that's the end of your job, and you have very limited legal rights to fight your termination. If you are employed at will, your employer does not need good cause to fire you. In New York, employers are free to adopt at-will employment policies, and many of them have. In fact, unless your employer gives some clear indication that it will only fire employees for good cause, the law presumes that you are employed at will. However, there are cases when termination will be considered unlawful. For example, you cannot be fired because of certain characteristics, such as your race, religion, or gender. Similarly, you cannot be fired because you've complained about unlawful discrimination or harassment, or about certain health and safety violations in the workplace. And you cannot be fired for exercising a variety of legal rights, including the right to take medical leave, to take leave to serve in the military, or to take time off work to vote or serve on a jury. Am I employed at will? Generally, employees in New York are employed on an at-will basis. However, if you have a signed employment contract that promises job security, you are not considered an at-will employee. For example, if your contract says that you are hired for 1 year and can be fired during that time only if you commit a crime, you are not an at-will employee. When it is illegal to terminate on the day off. While at-will employment does give everyday employees the freedom to change jobs at will, it understandably has negative consequences when it seems that employees are terminated unfairly. For example, assume an employer sets a weekly schedule and assigns each worker a day off. An employer is permitted to thereafter change his or her mind and not allow the employee to take that day off. In fact, it may even be considered insubordination to refuse to work. That said, there are some common exceptions to this general rule that may apply. However, there are still several situations when termination on the day off could be proven wrongful. New York's 1-day rest in 7 statute. Like many states, New York also has what is known as a 1-day rest in 7 statute. Under this law, certain employers are required to provide their employees at least 24 consecutive hours rest in any calendar week. Employers covered by this law include those operating factories, mercantile establishments, hotels, and restaurants. Any employer in non-compliance with this rule must answer to the New York Department of Labor. So, if you have been working for 6 days during a week and you are forced to work on your day off after the 6-day work week, this is illegal. If you refuse to work on the 7th day and you are covered under the statute as an employee, your employer has no right to fire you for this. Many employers consciously or through the lack of knowledge violate this rule. There are several exceptions for this rule, as stated in Section 161 of the New York State Labor Law. Also, New York law requires employers to keep a time book counting the exact time every employee worked. Failure to keep a time book could result in penalty, and could be considered a violation of the labor law. Religious accommodations requiring employee time off. Employers cannot legally require an employee holding strict religious convictions to come into work on religious observance days. Under federal and state laws, religious employees are entitled to a reasonable accommodation of their genuinely held religious beliefs, unless the accommodation poses an undue burden to the employer. This accommodation can require employers to permit religious employees to wear certain religious clothing at work, or abstain from performing certain job duties. An employer's duty to accommodate also extends to allowing religious employees time off for religious observances. This means that if you are an observant Jew, your employee cannot force you to work on Saturdays. Your employer cannot make you work Easter Sunday if you are a Christian. As simple as this seems, this type of requirement often raises disagreements between employer and employees. Often, employer claims that the worker is not that religious, that beliefs are not genuinely held, and refuse to provide a reasonable accommodation. Remember that failure to provide religious accommodations may constitute religious discrimination, which is forbidden by law. Question: can I be terminated because I was on a sick leave? Answer: it depends. If you are out on leave under the Family and Medical Leave Act or under the American with Disabilities Act, you cannot be terminated because you took a medical leave of absence. It is also illegal to fire a person who was on leave for jury duty. If your employer forces you to come to work while serving on jury duty, you have a right to file a claim. If you are out on leave under the Family and Medical Leave Act or under the American with Disabilities Act, you cannot be terminated because you took a medical leave of absence. Question: what to do to avoid being fired on your day off? Answer: check if you are working under a contract that guarantees your job for a certain period. Check if you have a reason to believe that there is an implied contract. Consult a lawyer about it. If you practice a religion that requires you to observe religious holidays, like Sabbath, make sure you let your employer know about this in advance. This will protect you against accusations that you're just pretending to be religious to get a day off. Keep a time book of your hours worked. This could help you if you decide to file a claim for unlawful termination. If you are confused or don't exactly know what you are entitled to, consult an employment attorney to know your rights as an employee. Question: what to do if my employer threatens to fire me if I don't work on my day off? Answer: check your time book. If you had 6 working days and 40 hours and you were called in on a day off, you have a legal right to refuse to work if you are covered under New York's 1-day rest in 7. Remind your employer about it. In case this is a religious holiday that you observe, inform your employer about it. If you have a written contract that guarantees your job, remind your employer that under that contract, you cannot be fired for refusing to work on your scheduled day off. Document all interactions with your employer, especially if you're informing that employer that you have a religious holiday or you are out on medical leave. Consult an employment attorney immediately. Sometimes a qualified letter from an attorney is enough to make your employer reconsider its actions. If you believe that your employer has violated the law or believe that you are owed overtime, you should call an experienced employment law attorney to help you resolve this issue with your employer. The law offices of Uri Mashis provides white glove service to all our clients and may be able to help you resolve any issues that arise with your employer. We help workers in the New York City area, including all its boroughs: Manhattan, Brooklyn, Queens, the Bronx, and Staten Island.